My Lords, my Lady, before the adjournment, I was addressing the adjustment provision itself, and I've been through elements 1 and 2, the condition and the event.
Yes.
I was on element 3,
Yes.
the mechanism. I've already addressed you on such reference year and a fraction. And after those 2 points, the clause, or this element here, then goes on to identify the numerator and the denominator for that, we say, single fraction. And one can see, just looking at the terms of this now on page 36 of the core bundle 2, one can see from the choice of each that the idea is to scale up the base case figures by the proportion which the actual real GDP in the new year of base prices has to actual real GDP in the old year of base prices. In other words, it clearly envisages a year in which both those metrics will be available. And following a rebasing, that in the ordinary course will not be available for any year after the year immediately preceding the year in which the change is made. And you'll remember I showed the court this morning the material relating to that, paragraphs 101 of the judgment and the expert's agreed statement, paragraph 11. The old measure of GDP, in this context, the 1993 measure, will not be available in the usual course going forwards. And indeed, as we said, that's never happened anywhere in the world before. And so the immediate preceding year will be the first reference year in respect of which the rebasing would be relevant.
Where are you getting the immediate preceding year from?
Well, my Lord, I'm sorry, that comes from...
different definition.
My Lord, I'm sorry.
That's in a different definition.
My Lord, yes, in 2 different definitions. Yes. Those in relation to growth, in particular the base case GDP growth, it requires you to look at the immediate preceding year. And so what we're saying is that if you have the change in base year in 2013, you have to be adjusting in 2012 because that is the immediate preceding year. So you have to have that adjustment. And that will be the year in which, in the ordinary course, both these metrics that are looked at in the mechanism will be available. And it will be the only year in which needs to be adjusted where those 2 metrics will be available. And that's because, as I've sought to identify, in the usual course, the old measure of GDP will not be available once the change has been taken. So when you go back to the wording of the clause, the reference year being referred to in the numerator and the denominator is not to the numerator and denominator of each reference year to be adjusted. That wouldn't work temporally. In other words, it couldn't be done at the same time. As I previously submitted, it needs to be done. Secondly, it wouldn't produce a single fraction. And thirdly, it wouldn't be possible after the 1993 series has been stopped. So what it must be, when one looks at the numerator and denominator, is a reference to the reference year in respect of which the question is first being asked following a change in base year and the triggering of the proviso. And remembering that this definition of base case GDP starts on page 35 with a reference to any reference year with that determinator, which can be referring to a particular year. And in context, in our submission, on the triggering of the proviso, in other words, the condition and the first element of the clause being satisfied, The year being referred to, which is picked up in the last 3 lines of the proviso, is the first reference year which must be adjusted at the time of the change in year of base prices. In other words, here,
Just say that again.
2012.
So
It's the last.
we're multiplying the base case GDP for such reference year as set forth in the chart. That seems to refer to all of the years set forth in the chart.
My lord, each year, I completely agree, each year, each reference year has to be adjusted. When one comes to identify what the fraction is and what the numerator and the denominator is, we say that it can't be a reference to individual fractions in respect of each year,
Yeah. no,
for the
further.
3 reasons I've been through.
But so such reference year as set forth in the chart means all future reference years,
Yes.
and the numerator, which shall be the actual real GDP for such reference year, is only referring to the year in which the change is made.
No, it's referring to the year immediately preceding, the first year in respect of which the question is being asked. And the question is being asked in respect of 2012, because you have to have the answer to that, an adjusted base case, so that you can, in the context of these securities as a whole, then measure whether there has been base case
Having
growth.
got that fraction, you then apply it to all the years in the chart.
Yes, yes, you do.
Right. What tells you to do that?
The term, well, we say the terms of the clause, but the particular terms. You've got your condition being satisfied, which is triggered at any time. The event, the then clause, requires mandatory obligation each reference year to be adjusted. You're then looking at a fraction. That, because it's a fraction, clearly has got to be, we say, 1 reference year. You then try to discern what the reference year that has been looked at. You get a very good heads up from the fact that it's comparing 2 measures. And those 2 measures in the ordinary course will only be available for the immediately preceding year, unless a term is implied, and I'll come to the implied term later. But just assume now that there's no implied term. This would not, in the ordinary course, work for any year other than the immediately preceding reference year, which is, as I say, the first year in respect of which this question needs to be asked.
So just so I'm clear, the trigger, as you describe it, in the first line and a half, is a reference to the first year in which the new year of basis price is applied.
Yeah, yes, once there's a change.
That's the trigger year.
Yeah.
But the reference in lines 7 and 9 to such reference year is not a reference back to that year, but to a different year, namely the preceding year.
But on the condition.
Sorry, that is your construction, is it?
Well, with a caveat, in relation to the condition, there isn't actually a reference to a reference year. The condition in the first element of the clause is identifying a time when the condition is triggered. And
yes, but that's a time. That's not a time by reference to a day or a month. It's a time identified by reference to a particular reference year, isn't it?
Well, it's first of all, we would
Doesn't
say
matter when you choose your new reference year, whether you choose it in March or April or July, or indeed the following year or 2 years later. It's the reference year itself that matters for the trigger, surely.
Well, we would say what matters is the time when there's a change.
Yeah.
And then, of course, those reference years that need to be adjusted as a result of the change are the relevant reference years.
Well, it's not strictly speaking the time when there is a change, is it? It's the reference year in respect of which there is first a change. It's not when the change takes place. It's the reference year. It doesn't matter, does it, whether you choose to rebase in 2004 prices for 2013 in 2014 or 2015 or 2016. 2013 is still going to be your trigger year.
Well, Mother, we would agree with that, though, but with one quite important caveat. What you're identifying there is that the reference or the base year, the year of base prices, has changed. In 2012, it was 1993. In 2013, it's 2004. But what this is targeting is any reference year to which the change is relevant. And it's wrong to say that 2013 is the first reference year to which the change is relevant, because it's not. The change is relevant, first of all, to the immediately preceding year, which is 2012.
Why isn't it relevant to 25, 26, 27 and 28, for which you can backfill the prices? Why the immediately preceding year? The 2012 official figure would have been in 1993 prices.
Yes.
So the comparison is between the official figure and a figure which is derived from the new rebasing, which is part of the, I've forgotten what you called it, back something or other.
Backcasting.
Backcasting.
Yes.
But you could backcast back to 2004. So why choose the immediately preceding year, as opposed to one of the others, or an average of the others, or whatever?
Nothing before 2011 needs to be adjusted.
You say it doesn't need to be adjusted.
I'm so sorry.
You say it doesn't need to be adjusted, but why not?
Well, because there's no function, no purpose in it being adjusted. What needs to be adjusted is the immediately preceding year, so that you can, after a rebasing, operate the terms of the securities. On the previous years, 2011, 10, going downwards, they have no need, they're not relevant for these particular purposes. And the first year in respect of which you do need it, and you do need to affect the change, take such course, adjust the base case as in the terms of the event condition to reflect any change in the year of base prices. That needs to happen in respect of, we say, 2012, the immediately preceding year. And as you've seen, well, indeed, just to finish it off, although I've made the point, and I'm sure my lords and my lady has it, 2012, when you're looking not so much at the question of going backwards, but of going forwards, it can't be a later year unless there's some implied term, simply because the information necessary to apply the fraction in respect of a later year, including 2013, is not there. And that's important when one's trying to work out, discern through the process of construction as what this particular fraction is designed to do. Now,
sorry, can I'm just a little bit behind you. I understand what you were just saying. I just wanted to jog back a bit. So the such in the such reference year in lines 5 and 7, you say is to the first year to which the change is relevant,
yes.
Which has to be the year preceding
Yes.
the year in which the basis change takes place. But why is that necessary? Why does that make it necessary to treat that as the relevant year? If you take such reference year, even assuming for the moment that it's a one-off, if you take such reference year as one which, as part of the mechanics of applying the fraction, is going to change all the figures,
Yes.
including the figures going back previously, why do you have to choose the actual real GDP for the previous year to make the change, rather than the actual real GDP for the year in which the year of basis changes?
Well, my lords, simply because in the normal case, you won't have the 1993 comparator, so you won't be able to do that calculation.
But you've got the comparative by backcasting, and if the purpose is to provide a more accurate estimate of GDP, I might have thought that the relevant year was the year of the base price change, that is to say 2004, not 2012, by which time you're already 8 years away from the snapshot of the economy that you've taken.
Well, my lord, in a sense, has the point. You don't need to adjust back to 2004. You do need to adjust 2012 and 2013. If we're right on the trigger, that any time, meaning from the moment in 2013 there's a change in base prices, from that moment and at that moment, this clause requires there to be an adjustment to each reference year. And then you're asking the question, well, hold on, at that particular moment, which base year am I asking this question? Sorry, which reference year or which reference years am I asking this question in respect of? And the answer to that is not just 2013 and the years after that, it's 2012 and the years after that, because you have to have that immediately preceding year adjusted as well.
And the reason, just to be absolutely clear, the reason you have to have that 2012 adjustment is because you needed that to measure base case GDP growth.
Yes, yes, absolutely.
Which we went through earlier.
Yes.
So
And
you say, as I understand it, you're saying, yes, there may be figures available for earlier years via backcasting, but relevantly, we know we've got to use, in this example, 2012. We've got to use a 2012 figure.
yes, indeed.
Sorry. Finish your answer.
Well, I was just agreeing. You are directed to 2012 because that is the first year in respect of which the question is raised. And so when you're looking, and we agree that those last two suches are referring to an individual year because that's the only way you can identify a fraction. You're necessarily funneled towards the immediately preceding year.
Well, that's so for growth. But what about the level condition? For the level condition, one might have thought that you'd be looking at just the year in which the change takes place. You don't have to go back to the previous year to calculate whether the level condition is fulfilled, do you?
No, that's right, my lord. But then what the level condition will be determined in any event by the rebasing. It will be a consequence of having used 2012. But my lord is right that the level condition doesn't necessarily require 2012, but the growth condition does.
Well, only on the hypothesis that you won't have new basis figures available you won't have old basis figures available in the first year of the new basis.
Yes.
That apart, is there any logic in choosing the previous year?
Well, the logic is simply that I've identified. It's the first year in respect of which you need to ask the question.
Yes. But if you use let's use 2013 and 2012. If 2013 is the first year of rebasing in 2004 prices, if you use the 2013 year, it will change the base figure for 2012. So you don't need to use the 2012 actual GDP for that purpose. You can use the 2013 GDP. I understand your point that you need to have the 1993 basis figures for 2012 available to do that, or for 2013 anyway. But that apart, is there any logic for doing it by reference to the 2012 year, the immediately preceding year, rather than the year in which the change takes place, when certainly for the level condition, one would have thought that was the natural way of doing it?
Well, my lord, a case could be made for 2013, but it is blocked in practice we say for two reasons. First is the point that your lordship has asked me to put to one side, which is the information will not be there in the ordinary course, and wouldn't it be known not to be there in the ordinary course as part of the general background in relation to how GDP works. That relates to the implied term, and I'll come back to that. But it is important and really quite fundamental. But then the logic we say is that when you're faced with a trigger that works at any time, and you're trying to identify the year which is being asked about for the purposes of working out the denominator and the numerator, then the logic drives you to the first year in respect of which you ask that question. But those 2 points go very much hand in hand. Now, the learned judge rejected this construction, and he reached what he described as a clear conclusion that it didn't reflect the wording used. In contrast, he said to the respondents' construction, which he described variously as being faithful to the wording in paragraph 182 and requiring no departure from it in paragraph 198. Now, the judge's reasoning on this is set out in paragraphs 181 to 198 of his judgment. And perhaps I could just ask you to turn that up. And as my lords and my lady know, we make a number of criticisms of the judge for failing to conduct a proper iterative process, and indeed forgetting his own earlier findings on the purpose of the securities. And I'll return to that later if I may. But for now, what I intend to do is just to look at his treatment of the linguistic issues. And starting at 181, really the first point of substance, having summarized his views in 182, is his conclusion in 184, where he's agreeing with the respondents as to the use of the word each and such. And that's effectively based on the words that he's underlined in the reproduction of the adjustment proviso in paragraph 183. But what he failed to grapple with here was what we would call the temporal requirement, in other words, at any time, and the significance of the mandatory adjustment obligation applying to each reference year in line 2 of the proviso. And he's able to achieve what he does by equating in 185 the first such reference year to any given reference year. One sees that in line 2 of 185. So he equates it to any given reference year rather than to each reference year which needs to be adjusted. Now, we agree, as I've said, that the fraction needs to come from the input of one reference year. But in our submission, the language simply does not tell you that there are going to be different fractions calculated on an annual basis for many years after the time when the year of base prices has changed from 1993. And indeed using, as we say, a measure of GDP in 1993 prices, which had long since been discontinued. Now, I'll return to the commercial consequences and we would say absurdities later. But first, perhaps I can just show you briefly the judge's other reasons on the language. In paragraph 187 on page 135, what he does here is refer to our alternative case on chart book. That is, with the greatest respect to the judge, irrelevant for present purposes. What we're looking at here is the construction, the proper construction on the words here, and not the correction of a mistake. Now, 188 to 189 refers to a commercial consequence point in relation to the base case growth percentages. In other words, the 3% point referred to earlier, which of course isn't a forecast of future GDP. It is intended to identify a benchmark of potential GDP going forward. Again, I'll return to that in relation to the matrix argument. But the essential point is that if a one-off adjustment were performed, the whole base case table would be recalibrated going forward. I think my lady have the point. And the long-term growth trend embedded in the table would be replicated in the revised table, something that doesn't happen with the respondents' construction. The short point, though, picking up in paragraph 188 in the last line, is that our construction comes into play first on the language of the clause, and it is separate from, at this stage, the commercial consequences, which I'll address separately. From the linguistic point of view, it is our case, which the judge appears not to have treated as being our case, that on the language, you are actually driven to the construction, we say, in any event. Now, paragraph 191 seems to be targeting the concept of overlap year that I've referred to. But again, an overlap year or transitional year is inherent in the proviso and in the concepts of actual real and base case GDP growth. It's inherent in the proviso because you are requiring actual real GDP in those two measures in at least 1 year. The respondents' construction requires multiple overlap years. They require, I think, 22 overlap years. So there's not in doubt that an overlap year at least is required. And of course, if the 1993 measure is discontinued after the change, which without the implied term to continue it, it would be.
Well, when you say they require 22 overlap years, you're using overlap simply as one of the years which is adjusted every time.
Yes.
But they're not specifically adjusting the overlap year. They're adjusting all the figures annually.
Well, they're not
just the same way as you are. But you're having to choose a fraction which applies to your one-off adjustment to a year which isn't expressly identified in the clause anyway.
I accept that, my lord, but it's in a sense a much more narrow point here, which I probably don't even need to make.
You don't need to use the word overlap to make the point. You just say a series of adjustments.
But there is that concept there that is inbuilt into the proviso, and it's inbuilt into the growth provisions of actual and base case GDP. Now, paragraph 192 is essentially a repeat of the point in paragraph 185. And we agree that we treat the last two suches in the adjustment provision as referring to the first reference year to which the rebasing is relevant, and the first such on page 36, we say is a reference to each such reference year. But it does, in our submissions, work. And picking up a question that my Lord Justice Lewison asked this morning, it could be tested by an example. If one looks at the position immediately after the rebasing in 2013, you have to, we say, ask the question for 2012, the immediately preceding year. So you run through the base case definition, the adjustment provision definition, with 2022 being the relevant any reference year at the start of the clause on page 35.
Do you mean 2022?
2012, do you mean?
I am so sorry, and thank you, my lady. Yes, 2012. So you run through that with 2012 being the relevant any reference year at the start of the clause on page 35. And the proviso is engaged, the condition is satisfied, and the fraction on our case, our construction, to adjust each reference year is based on the actual real GDP for 2012.
So do you mean that 2012 is the any reference year in the opening?
Yes, you're asking the question in respect of that.
So we're just, at this stage, we're just applying the definition to 2012, as I understand it.
Yes, yes, but you're asking the question. So when it says base case GDP means for any reference year, which means each or any, it doesn't actually matter which for those purposes, but you're trying to run through the definition. And you're asking it for 2012 because that is relevant, because the condition has been triggered for the reasons I've been through before. So you need...
Been triggered because of what's happened in the 2013 year?
Yes, indeed. But it means that you have to look to 2012. So you run it through. You run through the definitions on page...
I mean, that does mean you weren't right to say that the reference year you're talking about in the first line and a half is 2012. The reference year you're talking about for the trigger purposes is 2013.
Well,
in your example,
what my lord is doing there is identifying the reference year or associating the reference year with the time in which the change is made. Yes, the change is made in respect of 2013, but you're also asking the question because the immediately preceding year is relevant under the securities. You are asking in respect of that reference year in 2013, when this at any time has occurred, you are asking the question. You have to ask the question in respect to that year because the other definitions push you there.
So just let me see if I've understood this. We're asking the question for 2013.
Well,
But in order to answer it, we need to do a calculation involving 2012.
well, my lord, I would put it that you're asking the question first for 2012 because it is the first year consequent upon the change of the year base prices, which needs to be adjusted.
Yes, but sorry, just to be really clear, the only reason you need to ask the question for 2012 is not to compute what you're paying out under the securities in respect of 2012. That looks at growth over 2011. It's because it's relevant to determine whether you've met the performance condition in 2013. Is that right?
Yes, indeed.
I'm leaving to one side the payment amount at this stage. That's its only relevance, isn't it?
On the payment conditions, yes.
So the actual real GDP for such reference year means the 2012 GDP on your example.
Yes.
Even though it's not a reference year for which you're asking the question.
Well,
It's maybe a comparator for the year in which you're asking the question, nor is it the year in which the change actually took place, nor is it the year of the new base prices.
my lord, just unpacking that. It's not the year in which the change has taken place, but it is the first year in respect of which the question is asked, because you need an answer to what base case GDP is in 2012. Otherwise, it doesn't work. So it has to be adjusted. And it's the first one that you're asking the question in respect of. And just running through how it works.
So put it another way, it's the first year in which you have to think, in respect of which you need to think about the proviso.
Yes, indeed, indeed, absolutely. My ladies put it much better than I have. But what you do when running through this, you get your fraction from that year. You will then, and of course, in respect of that, each of the denominator and the numerator will in fact be available for that year. you then apply it and adjust by that fraction each reference year as set forth in the chart above. So they're all adjusted. Now, you then ask, picking up what my Lord Justice Lewison asked me earlier, you then ask the question for a subsequent year, say 2016. But in relation to 2016, if you're asking the question in respect of the change of base year from 1993 to 2004, that adjustment to reflect that change has already taken place. It's taken place when you've got the answer to the question.
No, I understand that. Once you've established the fraction on the basis that you do it once, which is your case, you then have a single fraction which you can then apply to all the figures in the table.
Absolutely. So that when you come back on any later year, it would only be if there's a further rebasing that the circle and the like will begin again. Now,
I'm sorry, it's my fault. I still don't quite understand why you're saying that 2012 is the first year in respect of which this proviso requires you to make an adjustment, as then justifying taking that as the reference year for the fraction. As if you take 2013 as the reference year for the fraction, that will equally alter 2012 and give you your comparison. I've got your point on the 2013 figures not being available.
Which is a very important point.
And we're going to come back to that, and I have some thoughts on that, but I'll leave that till you deal with
Yes.
slide 7. But in what you're saying, there's the logic of the clause. I don't understand why there's any logic in using the 2012 year for the fraction, when, if as a matter of practicality you could use the actual year in which the change is made, which will change the 2012 year.
Well, my lord, that's right. But we say it's a combination of the different pointers in the clause that point you to 2012. And indeed, this fact that that's the only year in respect of which the information will be available, and which is, if you like, representing where those two as a comparator as to where the 1993 base and the 2004 base is at the moment.
Sorry, I don't see why you say it's the only year, because backcasting gives you the notional figures for all years back to 2004.
My lord is right.
You gave a different answer as to why you chose 2012 rather than an average or some other method, but it's not the only year in which the information is available.
My lord, I was addressing my lord's point in relation to 2012 or 2013.
Oh, I see.
In relation to 2013, the information won't be available unless there's an implied term. And that's the important pointer. And we do say logically, when you are asking that question in respect of the first year in respect of which it arises, whereas my lady has identified in respect of the first moment at which the adjustment proviso is relevantly engaged. Now, we would agree that our construction is not grammatically perfect, but neither is the respondent's construction, as they disassociate the first such on page 36 in the adjustment proviso from the reference to each reference year immediately preceding it.
Sorry, can you just repeat what you say there does?
Yes, certainly. In relation to the respondent's approach,
Yes.
what they say, as indeed the judge said, and this is his paragraph 185, when he treats the first reference on page 36 to such reference year as being to any given reference year. In other words, disassociating the such from each reference year. Now, the judge did that, the respondents do that on their construction. And one can see that there are arguments linguistically as to how that might be possible. But the language doesn't work perfectly in that sense for either of us. Because if you're looking at the clause as a whole, you would say that our construction is simply a much better fit for the four reasons that I've been through. Namely, first, the at any time language in the condition clause. In other words, it's a one-off adjustment when that time arrives. Secondly, the event clause tells you it's a mandatory adjustment of base case GDP for each reference year at that time. Thirdly, that adjustment is to be by a single fraction. And fourthly, that fraction is one which could only, in the usual course, exist for the immediate preceding year.
Are 2 and 3 simply the consequence of 1? Any time you say is one-off. Each reference year means each reference year, whether you do it one-off or annually. And single fraction is whatever fraction you get in the mechanics section, but it's only a single fraction in the sense that you mean it, i.e. applied once and on a one-off basis. If it's a different fraction each year, if it's applied on an annual basis, it's still a single fraction for each year. And I wonder whether 2 and 3 are really separate points, or just a function of your case, that it's a one-off, not a continuing.
Well, my lord, we think they're separate cases for the reasons that I've been through, because each has further levels of justification, in the sense that, for example, in the event clause, as I've called it, you have the mandatory adjustment, which clearly is to reflect any such change in the year of base prices, and it applies to each reference year. And in relation to the...
So it does on the respondents construction.
Well, my lord, it applies...
Clearly, they say it applies to each reference year in the base table.
Yes, I mean, that's right, they do. But that then draws back into the fourth point, that you can't actually, as things stand, do it. And it also ignores the first point. Because my lord, although...
I entirely understand that your first and your fourth points are independent of each other and of the other points. I just wonder whether 2 and 3 were really just the consequence of the consequence of those points as a matter of language.
In some respects they are, but they also are confirming of it, we say, because of the different language there. And my lady, I'm conscious that I slightly diverted from the judgment. Perhaps if I could just show you briefly the judge's other reasons, although I don't think there are actually many more relevant to this. In 193, he went back to the overlap year point. And you have my submissions on that. It's inherent in the provisos. In 194 to 197, he was dealing with the question of subsequent rebasings. And it's correct that on the face of it, the proviso on our construction does not address that specifically. But what we would say is that if our construction is otherwise right, this cannot be an obstacle, because it's obvious that the base case will need to be adjusted on each change in base year. Otherwise, the performance and level conditions could not be rationally applied. We've referred to this in submissions before the judge as a lacuna, which was shorthand for our pleaded case of an implied term for business efficacy, to apply the proviso, effectively mutatis mutandis, for any subsequent rebasing. And there are two other points, I think, just to flag on this. The first is that implying a term to this effect, we would say, is much less intrusive than implying a term that the Republic should continue to publish 1993 GDP data.
So I'm sorry, I'm interrupting a lot, but I have some difficulty with the idea that this can be expressed as an implied term, and it's directly contrary to the wording of the denominator, which has to be measured in constant 1993 prices. It's not implying a term that isn't there. It's saying that has to be manipulated so that it doesn't say in constant 1993 prices. It says in constant prices of the first rebased year.
Indeed, my lord, I accept that.
I mean, implied term territory. Do we imply terms which are contrary to the language of the...
Well, save that. It's not contrary to the language, we would say, because what this is doing, the reference there, is relating to where you have the first change. If you accept that it is implicit, that this language is intended, or the adjustment provision is intended to apply on subsequent rebasings, then you simply have to have a mechanism whereby that is done. And that would be achieved. And I think it
Actually,
actually...
start from the other end, which is, given that the expectation is that you'll rebase every 5 to 10 years, the expectation is that there would be multiple rebasings.
Yes.
And the clause has to be construed in a way which is effective, not just for a single rebasing, but for multiple rebasings.
My lord, I accept that.
Your argument might have greater traction if it said measured in 1993 prices, but it says measured in constant 1993 prices.
Well, my lord,
Which suggests that that is not to change. Whatever else it is, it's not to change because it's got to be constant.
well, say that constant, I think that means the year of base prices in the sense of the real prices at that time.
But it doesn't say year of base prices, it says constant 1993 prices. The definition of year of base prices already allows for 1993 to be changed. But this denominator, as my lord says, requires you to measure in constant something in constant 1993 prices.
The point that my lord makes is actually the point that our expert, Professor Hubbard, himself made, which is ground 4 of in
This
our
is your
notes.
Hubbard deflator point. But
The Hubbard deflator, he says, as an economist, he reads it exactly in that way. And so what you actually need to do is to deflate from 1993 or inflate from 1993. Now, I'll come to that in due course.
But however that may be, they're 1993 prices, whether you get them on a year of basis or you deflate from the actual. They are not what you say would be the effect on a secondary basing. In our case, 2004.
That's right.
Prices,
which
is what it must have intended, you say, on your reading of the clause.
Yes, well, we accept that if you've adjusted everything in 2013 to 2004 adjusted base case figures, if there is a subsequent rebasing to say 2018 or 2020, then of course you then have to do a further adjustment. And my lord is right that what is referred here in both the second line and the last line is 1993 is identified. But what must have been intended to make it work, if we're right that it applies on multiple rebasings, to make it right and to make it work, then what must happen is it's implicit that it occurs again, mutatis mutandis.
Okay, I mean, you don't, on your approach, obviously change the first reference to 1993 because that's the list in the table, which is in 1993. You say it's implicit that you have to be able to read in constant 1993 prices as in constant prices of the last year of the base.
Yes.
To
Yes,
you,
indeed.
so in your example, 2004.
Indeed, and in fact you see how we would read it in a slightly different context. In paragraph 187 of the judgment, where our proposed chart wording was set out, which I think summarises the way in which we would say this should be dealt with by an implied term. But just returning to the submission I was making, implying a term to this effect, we would say, is less intrusive than the term that needs to be applied to give effect to the respondents' construction, which is continuing to publish GDP data in 1993 for the next 20 years. And remembering always that the respondent's construction only works for future rebasings because it actually fails to rebase base case for each reference year at the time of the change to 2004 year of base prices. And what it does is it simply rebases or adjusts individual years as they go along, and indeed after they've been completed. And that, we say, is fundamentally inconsistent with the wording of the proviso, and indeed with the intent that a base case GDP should be a benchmark going forwards. But before coming to the commercial consequences, could I just address the respondent's implied term case? This was dealt with in the judgment at paragraphs 228 to 232. With the judge concluding in 232 that this was a non-issue. And it is really, it's really quite important, we say, to unpack the judge's thinking on this, as it does throw some light on where he has gone wrong. And it's important in this context to remember that if 1993 figures stop in 2012, the Republic's construction is the only one that works on the clause. And the respondent's construction can only work if 1993 figures continue to be produced until 2034. Now, I've already touched on the evidence as to the continued production of an obsolete series. And you'll recall paragraphs 101 of the judgment, paragraph 231, standard international practice not to continue publication. The judge said it would be unusual and perhaps even unique to do so. And the experts' joint statement, paragraph 11, where they say it's usual to discontinue the old measure. And there are no examples of it ever having been done worldwide.
Would it have been open to the Republic? Would it still be open to the Republic? Decide they're no longer going to use year of basis pricing, and they're going to go over to chain link pricing and that methodology. And from 2000 and whatever it may be, 2024 onwards, they're simply not going to publish anything on a year of basis.
I would need to give that consideration.
Now, there must surely be an implied term, mustn't there, that they would publish the data in a form which enabled the formula to be applicable, whatever it means.
My lord, I would tend to agree with that, but
and therefore, I think what the judge was saying, if what the formula requires is publication of data in 1993 pricing, that's the extent of the implied term.
well, my lord, I follow that, but one's just got to, I think,
What's wrong with that?
unpack it.
If there's got to be an implied term that you will produce the data which is necessary to enable the provisions to operate.
Well, excuse me. The way in which the judge approached it, and indeed the way in which my lord might be approaching it, is that you're looking at the consequences of the construction of the adjustment provision, not at the consequences of the absence of any provision to continue publication of the obsolete series as a factor relevant to construction itself.
I don't think that's the way my lord is approaching it, if I may say so. The proposed implied term is that there is an implied obligation on the Republic to continue to publish such data as is necessary to make securities work, whatever those data are. And then you can decide, are those data 1993 data, or are they year of base price data? Bearing in mind, as you told us right at the beginning of your submissions, that there are some countries who don't use base prices at all. There are different ways that you can calculate GDP on a rolling basis. So if one was simply looking at it from a macroeconomic stroke statistical point of view, there might be all sorts of very good reasons for Argentina to stop publishing any year of base prices. But I think you accepted in answer to my lord that you would be required to carry on publishing year of base prices statistics so that the securities could be made to work. Once you've got to that stage, you have to publish such data as is necessary. It doesn't help you in choosing between which kinds of data.
Well, my lord, there is, in our submission, quite a material difference. If you look at, for example, the definition of actual real GDP, which is talking about information as published by INDEC, whether there is an implied term to continue publishing it or not. I would tend to agree at the moment, subject to further thought, that there very much is likely to be an implied term to continue publishing it to enable this to work. But when you're coming to look at the construction of the adjustment provision, this is a different question. As I've shown, you go through it and you see, well, the claimants, the respondents' construction doesn't work in the ordinary course. And it doesn't work because this information will not be available. They then say, well, you fill that by implying a term. Now, if you have reached a conclusion that without an implied term, it is necessary to have the construction works, the respondent's construction works, because you need effectively information to be there to enable it to work. In a sense, fine, you can then approach the implied term on that basis. But what you can't do is say that I'm going to imply a term so that the information is there, and therefore the construction works. That's circular. You need to look not at the consequences of the judge's construction or the respondent's construction. You need to consider first the absence of any provision to continue publication as a factor relevant to construction. And you simply can't say, well, I'll imply a term. That's the critical ingredient in making the proviso work. But an implication based on the judge's construction obviously cannot justify the construction. It's conclusory. He is using it. He is using it in the sense of saying, this is my construction. He is not looking at it in the sense of looking at the language. Does it work without an implication? And you have to try to identify, well, what is the basis on the wording of the clause for there being an implication other than the conclusion that he's reached, that that is the right construction. These are separate points. And there are two particular points, I think, that flow from this. The first is that given the accepted background that continued publication is unknown and has not been done by INDEC, it's quite extraordinary, we would suggest, in a document such as this, that the parties didn't stipulate for it if it was in fact required. There's no reason at all why they wouldn't if the proviso had been intended to operate in that way. And that's indeed all the more so because the one piece of academic literature before the issue of the securities, which the respondents have found, and which they say supports commercially their construction, is one that advocates an express stipulation if this route is to be gone down. And perhaps I could show you this very briefly. It's in Supplemental Bundle 1, tab 19. Beginning at page 290. And this is an article by one of the members of the Council of Economic Advisors in July 2004. And the relevant passage for these purposes is at page 296 to 297, where at the bottom of the page, the author, under the chapter heading Potential Concerns, is dealing with GDP revisions and methodological changes, saying that GDP data is frequently revised and investors may worry that the revisions or any methodological changes in compiling the statistics could complicate payments on growth index debt, though revisions tend to be smaller in emerging markets than in developed countries. Debt contracts should clearly outline the treatment of GDP revisions and methodological changes in advance. Then he refers, she I think refers to the simplest approach, but this is referring much more to revisions in respect of a particular year. Picking it up 6 lines down, changes to statistical methodologies could be handled by requiring governments to keep separate GDP series calculated with the old methodology, even after adopting a new technique for other purposes, until the outstanding contracts reach maturity. And then an alternative of referring to an outside agency is identified. And the footnote 17 picks up in relation to the solution adopted here in respect of index-linked bonds, inflation-linked bonds, which is the RPI measure, which is, as you will have seen from various submissions, completely different, because it is a statutory requirement here to continue the publication of RPI. And indeed, such index bonds here, as relate to RPI, have put clauses, or many of them do, that enable, if there is a material change, something can be done about it. So that is not comparable in any way. But what it does show, that article, we would suggest, that if it really was, as the respondents rely on that article to say, a possibility at the time, then why on earth wasn't there a clear requirement in the proviso or somewhere else in the terms that this should happen? Now that was the first point. And the second point is simply that without the judge's question-begging conclusion as to the construction of the proviso, there is in our submission no necessity and no business efficacy to ground the implication of the term. If you start from the proposition that the status quo continues, in other words, that INDEC will not continue to publish 1993 figures after the rebasing, only the Republic's construction works. I was going to move on now and consider, if I may, the commercial consequences of each of the rival constructions, which is, of course, a key element in the iterative process. And the first step, of course, is to just explain what the effect of each construction is or would be. And starting with the Republic's construction, and you don't see very much about the positives of our construction in the judgment, but the effect is really quite straightforward. Once the fraction has been determined for 2012, the overlap year we say, it is applied each of the reference years from 2012 onwards in the base case table. In other words, the base case is recalibrated once going forwards, with a new chart and benchmark being set out in advance for the following years. Now, this necessarily maintains the growth rates inherent in the table because each year is increased by the same proportion. So those growth rates, the potential growth rate, remain the same as before. And on the payment conditions, the level condition is assessed by reference to the new base case figures, and the performance condition again assesses actual real GDP growth against base case growth on the inbuilt percentages. And similarly, on excess GDP, the payment conditions, real GDP in the new measure is compared to base case in the new measure using the new figures in the table. So what you get on the Republic's construction is essentially a seamless recalibration to the new year of base prices, but with the measure of the Republic's economic outperformance and the payments to be made consequent on it, all being judged by reference to the most recent and updated estimate of the economy, which, as the judge accepted, remember in paragraphs 76, 78, is the best estimate of the Republic's actual economic performance, and of course the only official measure of Argentina's GDP going forwards. Now, the same is not true on the Respondents' construction. That construction requires an adjustment to be made for each year after the GDP statistics for it have been produced on the old and the new measure. And it is only then that you have the information necessary for their numerator and denominator. Base case GDP accordingly ceases to be a benchmark going forward, but becomes a function of observed GDP. An observed GDP in two different measures. In other words, not just the new official measure, but also the old obsolete one. And, excuse me, similarly with base case GDP growth, as it is only once the base case for the reference year in question and the immediately preceding year is known, it's only then that a level of growth can be determined. And that necessarily, other than by chance, will not be at the same rates inherent in the original base case table, as they will depend on the variable factor applied by the respondent's construction from year to year. And more importantly, though, is that the economic effect of applying the respondent's variable factor year on year is that the payment conditions, in other words, the level and performance conditions, are necessarily tied to the performance of the Argentine economy in 1993 year of base prices. That was agreed by the experts and indeed found by the judge. But perhaps I could just show you that briefly in the joint statement. It's the GDP security experts joint statement, paragraph 16.3, to be found in supplemental bundle 3, tab 47, which is core bundle tab 5. And paragraph 16.3 is internal page 8. And we'll see that 16.3 states as an agreed matter on the claimants and respondents' interpretation, the level condition and the performance condition are satisfied at the new year of base prices if and only if they are satisfied at the 1993 year of base prices. And that was addressed mathematically by both experts. It's not, I think, and indeed hope, necessary to go into the detail of the maths now, as not only was it common ground between the experts, was also accepted by the judge in paragraph 204 of his judgment, albeit there addressing something slightly different. But the reference, should the court wish to look at it separately, to the respondents expert, Dr. Boiter, is at his first report, paragraph 96, and appendices 1 and 2, which is in Supplemental Bundle 3, tab 46, pages 81, 95, and 98.
Is that something which is apparent from the language of the definitions, or does that only really become apparent if you crunch the numbers in the way the experts do?
I think the answer to that may be that it depends who is looking at the language of the definitions. It wouldn't, I think, necessarily be obvious to me looking at the language of the definitions until an expert points it out to me. In relation to sophisticated parties who understand how certain things work, certainly economists, analysts, and others who are possibly likely to invest in these securities, I think it may be a lot more obvious.
And that's why I'm asking. I can see that one can assume that an investor buying it on the secondary market should be treated as if they have available competent legal advice that looks at the document and tells them what the lawyer thinks it means. It's perhaps less obvious that they would have the advice that this is the result. If that's only, you'd only get there by crunching a lot of numbers.
Well, I don't think it's a matter of, I mean, if one stands back from it, it is actually quite simple because you're using fractions from 1993 as well as actual in the current year, but 1993 year of base prices, you adopt that as the denominator in the calculation. So therefore you are always going to have something that relates to the 1993 year of base prices.
That I understand, but I don't think what appears at 16.3, it's not obvious to me that what's said at 16.3 follows from what you've just said. You're definitely using 1993 pricing as the denominator in the formula.
Well, my lord, there wasn't.
I don't find it obvious that means you will get an exact correlation, so that you will only meet the condition if it would be met in the 1993 year of basis prices.
Well, my lord, I think it was fairly and immediately obvious, not only to the experts but to any analysts who looked at this at the time in 2014. And there are one or two, I think, analyst reports in unagreed bundles that might make that good.
But we're trying to interpret an instrument that was issued in 2005 and then again in 2010, perhaps not necessarily to sophisticated financial analysts or people advised by them. It just depended on who held the relevant debt.
Well, my lady, that's right originally, but if one's looking at the question as to say purchases in the secondary market, then it would be expected that people who will be acquiring this will be people who will be sufficiently economically literate to take a view on the economy and to take a view on how these conditions work.
Sorry, that's not the question we're focusing on though. We're focusing on the meaning of the words.
Well, yes, but one's got to be careful because I think there are two different factors that have come into play. One is the commercial consequence, the rival commercial consequence. And the point that my Lord Justice Popplewell has raised is a slightly different one. Well, would that commercial consequence have been reasonably available and known by people entering into it at a time before there's actually been a rebasing, which is a different question. And in relation to that, we would say, yes, it would be, because it would be reasonably available if one were to sit down and work this through to the sort of person or to the sort of advisor who would be advising the sort of person who will be taking this. But that is slightly different from looking at the rival constructions and the commercial consequences of them. And as my lords, my ladies knows, our argument in relation to this is that if you actually work through what this consequence is, it effectively renders futile the whole of the adjustment provision. And from our point of view, it doesn't really matter if anyone knew that or didn't know that at the time, because as a matter of fact, that would point, if they didn't know about it, to the other construction being the most likely. Why would they make any assumptions if they were unable to work through how this would work? Why would they make assumptions that there would be continuing publication of 1993 year of base prices? You have to have, on the claimant's construction, respondent's construction, you have to have assumed that you're living in a world where there's parallel GDP being published going forward. The person reading the clause at the time would never even have thought that. That's because our construction is right, so you don't get into this world. But if you are sucked into this world, what happens is that you get into a labyrinth where actually what you have, I think, 7 or 9 lines of dense drafting that ends up taking you back to where you started and serving no purpose. So we're not relying on this as advocating for our construction. We're relying upon it as showing that the respondent's construction, if you have so far got there on the language and the implied term, if you have, and you're still doing the iterative process, which of course is done sort of coherently together, you end up working out that actually it's completely pointless. But perhaps I can just make that good by showing how it arrives. Because it is really a key point that comes out of the respondent's construction, that the effect of it is that it keeps the measures of outperformance necessary for the payment conditions as measures in the 1993, in other words, the otherwise obsolete basis. And as a result, how the economy, the real economy or the true economy or the actual economy is actually doing in its most relevant and reliable measure is, on the respondent's construction, irrelevant. Now, the same applies to the payment amount. And you'll remember that the payment amount is determined in effect by excess GDP. And excess GDP, on page 36 of the terms, is the amount by which actual real GDP exceeds base case GDP, in each case multiplied by the GDP deflator. Now, rebasing is of course relevant to this because it is the rebased measure in current prices, which is the numerator for the GDP deflator, as we saw this morning. And there's no suggestion by the respondents that that is anything other than the most up-to-date measure of GDP. But while rebasing is in that sense relevant to the payment amount, the adjustment provision, or adjusted base case GDP, has no role to play in the payment amount on the respondent's construction. And that again is a matter of the maths and was proved by the respondent's expert, Dr. Boiter. And perhaps I do need to show you this. It is to be found in Supplemental Bundle 3, tab 46, page 84, where in paragraph 101.2, he addresses this. And you'll see what he says there. He says in Appendix 3A, I show that under the claimant's interpretation of the adjustment provision, the payment amount in any reference year at the new year of base prices equals the payment amount in that same reference year at the old year of base prices multiplied by a factor given by the ratio in that reference year of actual nominal GDP at the new year of base prices to actual nominal GDP at the old year of base prices. The payment amount therefore changes by the same percentage as actual nominal GDP. And just going to Appendix 3A, which is on page 100, there are a number of equations here. It's not necessary to go through them, but the relevant ones for present purposes are really right at the bottom of the page, equation 1.25. And if you're wanting to follow them at all, you also need to have a finger in page 94 of this bundle, which sets out the code. And just for simplicity, I'm going to ask you to look at the very last equation on page 100. EN 2013 is excess GDP in the new year of base prices for 2013. YN 2013 is actual nominal GDP in the new year of base prices for 2013. YO 2013 is actual nominal GDP in the old year of base prices for 2013. And EO 2013 is excess GDP in the old year of base prices for 2013. So you can see that EN 2013 equals EO 2013 multiplied by the fraction that he identified in a paragraph 101.2, and indeed explains in the narrative. See at the bottom of the page, from equation 1.25, following a change in base year, excess GDP for any reference year, including and following the overlap year, increases if and only if the value of actual nominal GDP increases as a result of the rebasing. The payment amount and the value of the security therefore increases whenever nominal GDP in any reference year, starting in the overlap year 2012, increases as a result of the rebasing. From the second line of equation 1.25, it can be seen that, according to the claimant's interpretation of the adjustment provision, rebasing changes excess GDP in proportion to the change in actual nominal GDP as a result of the rebasing. And the important point to note there is the point that I've already made. Yes, the rebasing makes a change because it makes a change to current prices, but the adjustment proviso is not relevant to that. On the claimant's respondent's construction, the adjustment proviso is irrelevant. And one sees that, it's perhaps easiest to show that by reference to Dr. Boyter's evidence and cross-examination. There's just two short extracts to show you, which are in supplemental bundle 4 at tab 63. Beginning at page 103. And this is Dr. Boyter being cross-examined by Mr. Valentin. Now, if I could pick it up, internal page 11, at line 13. Oh, excuse me. Well, Mr. Valentin says, it follows from that, doesn't it, that there's no role in the payment amount calculation after a rebasing for real or actual real GDP in the new year of base prices, in the sense that it doesn't feature in the, and then Dr. Boyter says, in the algebra, it drops out. Yes. And Mr. Valentin says it drops out. It's right, therefore, that under the claimant's interpretation, the measure of the Argentine economy's performance for the purpose of determining whether the economy has outperformed the baseline or underperformed it relies exclusively on 1993 base? Yes. Question, even after a rebasing to 2004 year of base prices? Indeed. And if I could pick it up again at page 106, internal page 21 in the top left, and in line 3, Mr. Valentin is pulling matters together. Just to summarize on this before I move on, the mathematical position on the claimant's interpretation, which you have looked at in your 3 appendices, following a rebasing, is that the performance or the adjustment provision makes no difference. We established yesterday with you, I think, whether the level condition or performance condition are met. They will be met if and only if they would have been met in 1993 prices. That's right, isn't it? Answer from Dr. Boyter, that's correct. So far as the payment amount is concerned, because adjusted price GDP plays no role in your equations, at line 123 and 124, the application of the adjustment provision to base case GDP makes no difference to the payment amount either. Answer, correct. Now, this was also subject to a fairly detailed post-closing, trial closing note from the Republic, which I'm not proposing to show you now, but the reference to it, should you at any stage wish to look at it, is at Supplemental Bundle 4, tab 66, and it's paragraphs 9 to 18 address it. Now we would suggest that there are 4 particular points that flow from this. First, the effect of the respondent's construction of the adjustment provision is not to reflect the change in year of base prices, but rather to make sure that it has no practical effect at all in respect of base case GDP. And that indeed was recognised by the respondents at trial when they described the effect of their construction as they put it, reversing out the effects of the rebasing. Now, secondly, the result of this necessarily is that it disconnects the securities from the updated and current measure of the economy. In other words, the Republic's actual, true or real GDP, producing, we would suggest, the absurd situation where the modern economy could be doing very well, but the 1993 economy is stalling, and therefore no payments would be made, and indeed vice versa. The vice versa being more obviously difficult for the Republic, not least because its payment obligations would not be based on its current economic outperformance or its ability to pay. And I showed you earlier, I think this morning, the document from the respondents' opening at trial that summarised in respect to the years 2004 to 2012 how the different measures are not linear in respect of growth rates between them. And indeed, I think I showed you Dr. Boyter's evidence from his report in paragraph 29, confirming his agreement that, as necessarily follows from the fact that the different base years are doing different things, you can have growth in one and negative growth or worse in the other. Now, the third point that comes out of this is that we would say, and do say, that this situation is fundamentally inconsistent with the purpose and intention of the securities as found by the judge. And you will remember in paragraphs 154 and 155 what the judge said there in terms where his findings, not challenged by the respondents. As he said, he accepted that the fundamental purpose of the securities was to ensure the sustainability of payments for the Republic, to stabilise its financial position and prevent another default. And his acceptance that the intention behind the securities was that payments would only be made when the Argentine economy was growing at a sufficiently healthy rate, and that they would not be made if the Republic's economy was not growing. That's important in that context. The respondent's construction does not meet that fundamental underlying purpose and intention. Now, the fourth point, in relation to the nuts and bolts of the adjustment provision, one has got to ask, well, what is the purpose of it on the respondent's approach? On the face of it, it would appear to be a clause which is intended to have some genuine commercial rationale. And as I mentioned earlier, in a document of this sort, you wouldn't normally expect to see 7 lines of close drafting, which ends up doing nothing of substance. And this is our so-called redundancy point in ground 1A of our notice of appeal, or at least that was the label put on it at trial. Although a why bother label would probably work just as well and possibly better. The short point is that the adjustment provision on the respondent's construction actually does nothing. And the securities operate in exactly the same way as if it were not included at all. And as we've illustrated in the annex to our skeleton, which is in Core Bundle 1, Tab 2, page 50. On the respondent's construction, you can simply put a line through the large measures of the definitions that we've been looking at. And I don't know if my lords or my ladies have an opportunity to look at this annex at page 50 at the back of our skeleton.
Yes.
But this shows what effectively the result of the respondent's construction is. Actual real GDP continues to be measured in 1993 prices. You don't need to deal with any rebasing because you're always anchored to 1993. You don't need the adjustment proviso, and you don't need the proviso to actual real GDP growth. But you do need the new operative clause, which is effectively the implied term that 1993 information continues to be published. None of that crossed out wording is necessary on the respondent's construction. So in the end, why bother? What is the purpose of having it in? Now, the judge addressed this
You don't need
submission.
any of that wording for any of the other provisions.
That's right. Yes. Now, the judge addressed this in paragraphs 171 to 180 of the judgment, and he appeared to have 4 reasons for rejecting it. This starts in paragraph 176, where the judge says, or appears to be saying, or he seems to be suggesting that the experts considered the adjustment provision to be relevant. And that's a little odd as the maths came from the experts. And although the judge didn't address the maths here, he did in paragraph 204, just going forward to that now, in a different context. This is in the chart book contract. He says in paragraph 204 on page 138, first and perhaps most fundamentally, the effect of the annual adjustment construction is that rebasing does not make a difference to whether or not the performance condition and the level condition are satisfied, since the annual adjustment construction ties the payment conditions to 1993 year of base prices. So the judge has made that finding. And one then comes back to paragraph 176, he seems to be suggesting that that wasn't the case, but the evidence, as I hope I've shown you, shows otherwise. And contrary to what he says in paragraph 176, Dr. Borenstein never accepted on the respondent's approach that the adjustment provision had an effect on rebasing. And if it's necessary to show you that, maybe in view of the time, it's probably sufficient just to give you references rather than go to it. It's Dr. Borenstein's first report, paragraph 39, supplemental bundle 3, tab 45, pages 45 to 6, confirmed in cross-examination, where he said that all that matters is GDP in 1993 base from the perspective of the claimant's approach. And that's supplemental bundle 4, tab 64, page 148.
I think all the judge was saying, wasn't it? It was that the way that the instrument is structured, you have got to have a proviso. If you only cross that bit out, then you'd be in real trouble, because the moment you have a rebasing, which may, you know, on these figures, double the prices or something like that, if you don't change the base table at all, you could be in 3% recession for the rest of the bond.
Although, in part at least, that's absolutely right.
So it's not a question, it's, your redundancy case is not, I think, that is redundant as drafted. In other words, you could just cross that out and you'd get the same result. It is, if you cross that out and you cross a number of other things out, you could have achieved the result for which the respondents contend without a number of different provisions.
That indeed
not merely without this one.
Yes, that is a point that the judge makes, and he also makes the point, and I'll be addressing these in a moment, the left-hand side and the right-hand side point, as you would have seen in the judgment. If you're adjusting one, you have to adjust the other. And so it's suggested, well, adjusting the other through the adjustment provision does something, because it puts you back to square one, neutralises the rebasing. And that's why it may technically be a question as to whether redundancy is the right label, which is why I prefer the why bother label. Why do this if you end up at square one? If you're not intending rebasing to actually have any effect in the terms of the adjustment provision, why have an adjustment provision if all you're interested in for rebasing is nominal or current price GDP? But if I could, I hope I'll be addressing those points in relation to the judge's findings in other paragraphs in a bit more detail in a moment. But just going on to his second point in paragraph 177 and 178. This is where, indeed, picking up what my lord has just said, the judge considered the redundancy submission and treated it effectively as a submission that the same result could have been achieved by a different means, purportedly citing my Lord Justice Lewison in Napier Park at the end of paragraph 178. That quote, though, does not appear, as far as we're aware, in Napier Park.
I couldn't find it either. I don't recall having said it. I've said it elsewhere, or
Yeah.
words to that effect, but not in that particular case.
Yes, well, I'm very glad that accords with our own review of it. But even without my lord's authority in that particular case, it's probably an uncontroversial proposition. But it simply misses the point here. And the point here is, well, why bother to include anything if no ultimate effect is intended? All it does is disable the contractual consequences that would otherwise flow from an adjustment in base case. So why? Why do it? Or put another way, a construction which deprives provisions of any practical effect would simply be futile. And that, we say, is the position here. Now, a partial answer
Well,
to
is that quite right? I mean, one might say, well, we have signed up to these securities. We know what we're getting. We recognise that the Republic may decide in the future to rebase the data which it publishes, and so we'd better do something about that. And what we want to do is to keep things as they were when we entered into the contract. And therefore, if there is to be a rebase, we need to write it out again so that we're exactly back to square one. There is a point to going back to square one.
Well, my lord, what they're not.
Might that be said against you?
I think it is. But what's not been done is writing out the rebasing. The rebasing is accepted and embraced from the point of view of current price and nominal GDP. It's the adjustment proviso. What it said is that we're not going to adjust base case GDP. We're actually going to get you right back to where you are in 1993. Well, we're not going to have an effective adjustment. Yes, there's going to be a fraction that applies, and you're going to go into the maths books, get out the calculator, you're going to apply the fraction each year once you've forced index to produce 1993 figures as well as 2004 figures so that the information is available. At the end of the year, you're going to go back, you're going to work out a fraction, and then you're going to discover, actually, there's no purpose in doing that whatsoever because it all turns on 1993. That's why we say it's futile. And a partial answer to it, though,
your rewriting on the claimants construction with the various deletions involves changing the definition of actual real GDP to mean actual real GDP in constant 1993 prices as published by Picken J. Now, Lewison might have thought that's a pretty odd way of defining actual real GDP, which we all know and expect will be published from time to time as in the year of basis prices as rebased from time to time. So we'll start by defining actual real GDP as meaning what you'd expect it to mean. That is to say, what the Republic treats as real GDP from time to time, based on your basis prices. But then we've got to do all the adjusting that's necessary to deal with changes in your basis prices and the effect that'll have on the table.
well, my lord, that's that's a fair observation. But my lord is living here in a world, the respondents' world, where you also need the operative clause at the end. Because your construction, the respondent's construction, is assuming...
Well, that's your implied term point. But if I can just keep you focused on the redundancy point, that's if what I've said is right, does that not illustrate that it's just they could have gone about it in a different way rather than it's redundant?
In part, in a sense, you can always say that you could do something different. But what you're intending to do as part of this construction exercise is try to work out what the parties actually meant at the time by the language. And it's a short and simple point.
But the answer to your question, rhetorical question, why bother, is because you've chosen, in the example I was giving you, because you've chosen to give actual real GDP a meaning, which is what everybody would think it meant. And this is the language you need to use to achieve that result. You could have defined actual real GDP differently, but that would have been a rather surprising starting point for everybody.
Yeah, well,
So
I
that's
see
why
that.
they've bothered.
Yes, but then you do need to ask the question, why have that starting point? If you have already necessarily reached the position where the new operative clause is going to be in play, because that's vital for the way in which they're running it. So you know that actual real GDP has got to be produced in 1993 prices. That's going to happen on their construction in any event. So that's your starting point. And is it actually logical if that's your starting point to say, well, that's what actual real GDP is? Because that's what they're treating it for relevant purposes, for the performance condition, the payment, the level condition, and the payment amount. That's why it's important. Rebasing, this doesn't affect rebasing because rebasing will take place in any event. It's just that what will not happen or what need not happen is any adjustment. You don't need to go through all this to end up at the start. Now, the other answer that's given to it, which we've already touched on briefly, is the one that the judge gave in paragraph 179. And this is the left-hand, right-hand side point, where he refers to the left-hand side of the equation changing on a rebasing. And that's a reference to the first element in the level and performance condition.
So sorry, can you give me the paragraph number again?
Certainly, my lord, it's paragraph 179. And just going back to show you again the level and performance conditions on page 38. The level condition is actual real GDP is greater than base case GDP, and the performance condition is that actual real GDP growth is greater than base case GDP growth. And so although the judge doesn't say so in terms, what he appears to be meaning is that there is a need and logic to do something to the right-hand side if you're doing something to the left-hand side, the right-hand side being base case and base case growth. Now, there is some superficial attraction to that. Objectively, there should be a recalibration of base case, which enables meaningful like-for-like comparisons. But what the Respondents construction does is that it removes the effect of the change to actual real GDP and actual real GDP growth from the equation. So in one sense, yes, it does do something, in that, as the respondents say, it neutralizes the rebasing, such that there's no need for any change to the left-hand side. But that is no answer to the why bother question, because you've also got to ask, well, why bother changing the left-hand side if you're just going to ask for a change to the right-hand side, which means you didn't need to change either of them.
And you come back to the same point on why define real actual GDP in that way. If you have defined it in that way, well then the left-hand side, right-hand side point is a good one. You then do have to make the adjustment, but your point is that's only because you've defined actual real GDP in moving euro basis terms, which on the respondents construction, it should simply have been defined in reference to 1993 prices.
Well, my lord, we wouldn't say it was a good point in any circumstances other than being purely mechanical, because what it doesn't do is provide any coherent commercial explanation for the adjustment provision. It's effectively saying, because we've agreed to adjust base case GDP to reflect the rebasing, we must make sure that adjusted base case GDP has no effect on the payment conditions or the payment amount. And so we must neutralise it.
Isn't your point more that it doesn't justify the use in the actual real GDP definition to, or indirectly year of base price definition to any updated index? Your real point is that the logical way to draft this, if the respondents were right, would be that everything is explicitly by reference to 1993, so that looking at the definition of actual real GDP, which refers to constant prices for year of the base, that would just mean 1993.
Yes,
And you wouldn't have the proviso at the end of that definition. And if you did that well, it is another way, if you like, of producing the respondent's case. So you really need to say that the wrong term, if you like, was there.
Well,
Was there.
at this stage of the analysis, what one's looking for is not only looking at the consequences, but also trying to identify some coherent, rational explanation for this being dealt with. And this is just, it's just not the way in which, if you were to set about the end result of the construction that the respondents urge on you, this is not the way that really any rational person would do it. It's purporting to do something of real substance. It's ending up just neutralizing itself and other definitions. So, my lady, yes, I agree, but it's not just the question as to, well, could it have been done in some other way? An answer to could it have been done in some other way is always likely to be answered by yes. We could have had several pages going out through a whole number of completely irrelevant mathematical fractions and formula and end up with where we started from. And I think it's a relevant question at the end. Well, why have you bothered to do that? There must be some reason for doing it. On our construction, there is. It's an obvious and clear one. And everything works on our construction. It's a seamless transition with one fraction. You carry on that basis. On theirs, you're perpetually, at the end of each year, having, as I say, put the Republic through the task of continuing to produce the 1993 figures, at the end of each year, you apply a fraction. Having applied the fraction, you work out that you didn't actually need to bother because you can work it all out in 1993 prices anyway. Now, the last point is in paragraph 180 of the judgment, the last point in this sequence, which actually I think I've already addressed, because this refers to the excess GDP and payment amount being changed by a rebasing. But just to repeat the point in this context, it's correct that excess GDP is affected by the rebasing because of current 2004 year of base prices. It's the numerator in the GDP deflator. But the adjustment provision and the adjusted base case GDP is irrelevant to this. And the economic outperformance, as you've seen, of the Republic continues to be measured in 1993 figures. And the judge criticizes here, in this paragraph, the use of a deflator. But the securities require a deflator to convert the economic outperformance in real GDP to nominal current prices. And the deflator deployed by Dr. Boiter is set out in his calculations as I've shown you, particularly calculation 1.25 on page 100 of supplemental bundle 3, tab 46. And you may remember that bit in brackets in the middle of equation 1.25, YN 2013, actual nominal in the new year of base prices, over QO 2013, actual real in old year of base prices. That is the deflator that he uses on the respondent's construction. Now, the judge then goes on to consider the language. I'm so sorry, I gave the wrong reference to the equation. This is equation 1.23, which I remember I spared all of us for going through the detail of it. But that is where you see that particular deflator, that proportion that he relies on to, in the terms of the deflator, to be getting a ratio, which is the ratio of actual nominal, i.e. current prices, 2004, to actual real in 1993. And that's where that comes from.
But that's just in the terms of the securities as well, that deflator.
Yes, the requirement for a deflator is in the terms of the security. What happens, though, on the respondent's point is that when you're looking at the terms of the GDP deflator on page 37, one remains current prices for 2004. Two becomes actual real GDP in 1993 prices. Because what they're doing, as they're working out outperformance by reference to the 1993 base, what you have to do is deflate or inflate from 1993 to here.
You've lost me.
My Lord, it's
The GDP deflated definition deflates by reference to the actual real GDP for the reference year, which if it's in a new series is in a new basis.
yes, indeed. That's what we say, and that's how it works in our construction. On their construction, they look at it as being that you have to, because they're 1993 centric, as Dr. Boyder has said, the deflator that you need to apply is to, from 1993 real to 2004 current. Lady, I was going to move on, but is there anything more that I can help you on?
How are we doing for time?
All right. I'm aiming to sit down round about 12 o'clock tomorrow on the basis of dividing the time more or less equally. I think I'm on track to do that. I'm assuming that my Lord is intending to rise at 4:30. Is that right? 4:15. Yeah. Having gone through those particular points in his judgment, the judge then went on in 181 and following to consider the language of the proviso. And we've already looked at that. But what I've shown you was his only consideration of the commercial consequences or the overall commercial sense of the rival construction before he turned in paragraph 199 to our alternative case based on chart book. Now, in addressing that case, he did address in 204 to 224 a number of economic arguments which are relevant to the iterative construction exercise. It's unfortunate, though, that he addressed them only in the context of the chart book target. In other words, that of a nonsensical, irrational, or absurd result, which I'll be coming to separately. And you can see from 225 that his conclusions were in those terms. Where he says at the end of the page, specifically, I don't agree with Mr. Barrington that the one-off overlap construction is the only interpretation which, as he puts it, gives any meaning to the language, gives effect to contractual language as a whole, is supported by the overall contractual scheme, makes any economic sense, and is consistent with the admissible background. In other words, he was looking at it as against the chart book requirements and not as part of a balanced iterative exercise of checking the consequences and implication of each rival meaning, and without any reference back to his previous findings in 154 and 155 as to the underlying purpose and intent of the security, or indeed the obvious commercial benefits which our construction brings, in particularly those of certainty, simplicity going forward, and the question of outperformance and affordability being measured by the best measure of GDP. Now, the judge did, though, in paragraphs 204 to 224, identify 7 points which he considered relevant to that part of his judgment. And it's convenient to address them now, if I may, and perhaps run through them as quickly as I can. In paragraph 204 to 206, the judge has his first point, which starts in 204 by, agreeing that the Republic's construction ties the payments conditions, as you've seen, to 1993 year of base prices, but then goes on, we say extraordinarily, to say that whatever the bargain was, the respondent's construction preserved it. A concept that is elevated in 205 to one of keeping the goalposts in the right place and the same distance apart. Language which you will have seen is echoed in many places in the respondent's submissions to you. Now you have to, in our submission, be very careful with this sort of language and argument because it's clearly question-begging and confusing. If you assume that the deal is 1993 forever, despite any rebasing, then it's a fair point. But that is the question being asked, and stating an answer doesn't provide a reason for it. So one needs to unpick what the judge considered to be the underlying economic or commercial justification. And it appears to be, if one looks at the last sentence of 204 and the middle sentence of 206, it appears to be that bondholders would want to stick with the known quantity of 1993 year of base prices and have the certainty of that measure through to 2034, rather than the uncertainty of what any rebased measure would look like. One sees that, I think, from the last sentence of 206. And those appear to be the obvious reasons which the judge suggests investors may have considered relevant. But with the greatest respect to the judge, this is just disconnected from reality. These securities are designed to enable holders to share in the Republic's economic outperformance over 30 years. They specifically refer to and envisage a change in year of base prices. And the questions to ask, which the judge didn't ask, are first, on what basis would any investor want to be excluded from the benefit of economic growth that is not caught by the 1993 measure, which by the end of the securities would be over 40 years old? And the point was well made, I think, in two places, which I would show you. First, in Supplemental Bundle 2, tab 42, which is right at the back of the bundle. There's an extract from a book by John Williamson.
Which one?
Supplemental Bundle 2, tab 42, right at the back. And this was published in 2017, but nonetheless the point made there is a good one. Mr. Williamson is a recognised expert in these matters. And if one picks this up on page 315, one sees the second new paragraph, where he says these three different approaches to designing securities unambiguously. A straightforward statistical way would be to specify in the contract the formula. Each issue of securities would have associated with it a particular GDP measure, presumably that is in use at the time the securities were issued. The solution could be applied to any of the three variants. The first disadvantage of this approach is its cost, since it would be necessary to calculate a number of GDP measures rather than just one. The other disadvantage, this is the relevant one for present purposes, is one that would become increasingly serious the longer the dating of the securities, since the GDP measure used would measure the increase in GDP, assuming that the structure of the economy had not changed. Would we really be happy to buy securities which assume away a substantial part of technical progress? And then he gives a specific example in relation to computers. And they were large exotic creations that shuffled punch cards and were housed in one of the few air-conditioned buildings on campus. Similarly, Professor Hubbard in cross-examination. And this is supplemental bundle 4, tab 62, at page 92.
Which page? 92, did you say?
92, yes, my lord, it's tab 62, page 92. Where he's being cross-examined, I think by Mr. Barden, but I do apologise for this proviso. Internal page 159, line 6. You were asked a little earlier in the day about the position with respect to investors and what they might think was put. I think you gave the answer at one point. You said no reasonable investor would want a security linked to a previous economy. Do you remember that evidence? Yes. Why is that? And the answer Professor Hubbard gives is, well, these securities for the court's benefit are all about macro risk sharing. That's why they were designed in the first place. So to be useful to an investor, you would expect to see payoffs in periods in which the economy is doing well and not in periods in which the economy is not doing well. It's, loosely speaking, what the security is designed to do. So no investor would want to tie that to an economy that isn't there. The goal would be to pick the current economy. In a sense, it's an obvious point. I'll show you that because it's an obvious point, just not of lawyers, but of experts as well. So that's the first question, which the judge should have, but didn't ask. And secondly, while the 1993 measure might be a known quantity, as I think he put it in 2005, having been introduced in 1999, once it ceases to be the official measure of GDP and ceases to be used for any relevant non-contractual purpose, it will become inevitably obscure. And on what basis, to pick up examples that the court has raised earlier, on what basis would investors in 2015 or 2025 want the securities to be governed by an archaic and obscure measure of the economy? And thirdly, on what basis would the Republic want to have to pay based on the 1993 measure when that did not reflect its then ability to pay and its then economic performance? Questions of sustainability and affordability, the fundamental purpose of the securities, and critical to investors and the Republic alike, turn on the measure of performance closest to the real or true economy, which will be the rebased measure. You remember this morning I showed you Mr. Davis's, the Respondents' expert evidence in relation to this, which included the importance of the updated measure. Now, as to the idea that the Respondents' construction gave some certainty in advance as to the level and growth of actual real GDP, which seems to be what is referred to in paragraph 206 of the judgment. This misunderstands the evidence and is, it appears, at best a jumbling of a number of different concepts. First, actual real GDP following a rebasing is in 2004 year of base prices. But on the Respondents' construction, there is no certainty at all in advance as to the level and growth required for that. That becomes only known after the end of the reference year in question, when the numerator and the denominator of the Respondents' fraction for each individual year is available. In other words, on the Respondents' construction, the investor has no idea at all in advance as to what level and growth in the actual economy, in other words, actual real GDP in 2004 prices, is required. And secondly, as to the evidence, neither expert suggested that any investor had any such certainty. And if the judge is suggesting that, he has got that wrong. And perhaps for these purposes, I could just again show you the GDP securities expert joint statement in supplemental bundle 3.
So just before you do so, would an expert not be able to model mathematically for each upcoming year what the actual GDP would need to be in the new basis?
No. Well, you could, one could always have a stab at it, but remembering what you're required to do, the variable factor that is being applied is actual real GDP in current prices. In other words, only when the year has been completed, and that statistic.
You may only know what that is once the year's been completed, but if the investor is trying to work out what will be necessary in order for it to exceed the rebased base prices, which are also dependent on it, that may be something that an expert can tell them, can't they?
Well, what you have to do.
I'd be surprised if mathematically that isn't an equation that could be.
Does it not follow from what you've been saying earlier that what the expert has to do is work out what the expected position is in 1993?
Well, indeed, if
so on your approach, he's working out whether he thinks the level and performance conditions are going to be met, he has to do some forecasts in 2004 prices, because by definition, even on your approach, you don't actually know whether these conditions are met until GDP figures are published.
Oh, I mean, that's right. As to whether they have been.
So what the expert's doing on the respondents construction, as you've explained it, he would have to do that equivalent exercise, but in 1993 version.
Well, what the judge is saying, and the point of the judges that I'm responding to, is saying you have in advance some clarity or certainty as to what the level and growth is required to be. Say in relation to that, no, you don't, because you.
I think your point is whichever construction is right, you don't have that certainty.
No, on ours, you know what it has to be, because you've recalibrated the base case and you know what the growth is. You'll know, for example, that you need 3% growth. You will not know on the respondents until you've got to the end of the year whether you need 0.1%, 5%, or whatever.
That's what I'm just questioning. Leave aside your point that the effect of this is to do it as if it was in 1993 prices. That may be the effect of it. But if I were an investor looking at this and I thought it meant what the respondents meant, say it means, you could say, couldn't you, to a mathematician, well, if real GDP this year is 4.2% in 2024 prices, what will that do to the base price, and will it pay, and if so, how much? Or if it's 4%, or if it's 3.5%, and if one posits each of those hypothetically as you'll be able then to do the calculation and see what the answer is. And all I was suggesting is that rather than taking a series of examples, I would expect a mathematician to have a formula that tells you what the answer is as to when the performance condition is met.
Just taking that in stages. While mathematicians can do a large number of things, as this case perhaps shows, one must remember that the relationship between the two different factors that goes into the respondent's equation is non-linear. You need 2004 and 1993 year-based prices at the end of the relevant year. You will not know what those are until the end of the year is. You're right, in a sense, that one could do an estimate or a projection and work out internally. But the judge says the benefit of the respondent's approach is that you have certainty in advance. You don't, because it's only once those particular exercises have been completed and you've got the data for the the nominator and the numerator, you can work out what the fraction is. You have certainty in advance for our construction because the base case table is recalibrated. And picking up the point that my lady mentioned, yes, you could proceed on the basis of 1993. And if you've done that calculation, you can say, well, what I need is just something that satisfies 1993, and that's the target, and it's in 1993 growth, and that's the level. But for that, of course, what you've got to be able to do is to be able to make assumptions as to what 1993 is doing, the obsolete measure, and of course it has to be continued to be published.
My rather more basic point is you're effectively saying that your approach gives greater certainty because you've got that fixed fraction. But what the investor actually wants to know is whether it's going to pay out in a particular year. And to answer that question, you can't just look at the right-hand side. The investor's bound to be trying to work out, project whether growth in that year or the level in that year are such that the conditions are met.
My lady may...
You're always looking at those projections, and you're either doing it in 2004 or potentially in 1993.
Well, my lady's right, I'm sure, that investors will be looking at the potential for payment, but it's very different to be looking at potential for payment in relation to the current measure of the real economy and how that is going to perform against whatever base case that is going to be produced on the respondents' construction. There's that on the one side, or measuring forward how an outdated economy that is no longer there and in respect of which official figures are no longer being produced as a measure of the economy, how that would operate. And they are two very different things. But the short point that arises in answer to the judge is that if you're trying to know what level of actual real GDP, i.e. 2004 real GDP is needed on the respondents' construction, you do not know until you've got past that year. And the judge simply didn't unpick it in the way that you've been suggesting, which then leads to different questions.
I think those questions will be addressed tomorrow.
Court is if payable.
10:30 tomorrow.